Hi, I'm Kate Callery, and until my recent retirement, I was one of the DAP state support attorneys at the Empire Justice Center for a number of years. I was there to support advocates around the state working under the Disability Advocacy Program grants. And I'm back now to take part in a series of trainings online called DAP Basics that will provide some basic, literally, information for newer advocates and more experienced advocates who just want a refresher course on some of the essential kind of terms and points and definitions that get bandied about in the DAP world and in other longer trainings that you might attend. It's a way to get quick introductions to things or reminders about certain topics. And what we're going to talk about right now is really an overview of the two Social Security programs, SSI and SSD. And we'll start with answering what is SSI. SSI stands for Supplemental Security Income, also called Title II, Title 16, because it was the 16th title of the Social Security Act. The Social Security Act itself was originally promulgated by Congress in the 1930s under President Roosevelt. And then over the years, new programs, new titles were added on to the act, and SSI came about in 1973 and was the 16th part of it. And it is a needs-based program that serves poor adults who are over 65, so it's for the elderly, or the disabled. So it's for both elderly and disabled, and also includes a program for disabled children under 18 whose families are poor enough. And DAP advocates we really don't deal much with the eligibility issues of those over 65, maybe some of the non-threshold issues, about income and resources. But we do you will be focusing your practice on proving disability for those trying to get on SSI, including disabled children. The program itself is administered by the Social Security Administration, SSA. Social Security Disability Insurance, or Title II, is an insurance program for disabled adults who worked. They have to have been wage earners and have contributed enough and recently enough into the Social Security system. The contributions are made through FICA deductions from people's paychecks. You'll see that in your own check. That's going to help support these claims, to help support your eligibility eventually for retirement benefits or, God forbid, disability benefits. Someone has to have worked recently enough and contributed enough into the Social Security system. The basic rule is that one has to have worked 5 out of the last 10 years to be considered insured for this program. Because again, it is an insurance program. So the FICA payments, the FICA contributions are really akin to insurance premiums that you're putting into the system. So no matter how disabled you are, you're not going to get Social Security disability unless you are insured. And again, that's usually 20 out of the last 40 quarters or 5 out of the last 10 years. You could be eligible for retirement benefits even if you haven't worked for a long time, but the disability requirements are different, specific, and more recent in terms of proving threshold eligibility even before you meet the strict disability determinations, which you'll be focusing on and we will focus on in other sessions. So comparing the two programs, Title II, SSDI, is also called Disability Insurance Benefits, Retirement Survivors Health and Disability Insurance. Again, we're not going to focus on the retirement and the health for the survivors, but the disability, same as OASDI, Old Age Survivors Disability Insurance, whereas Supplemental Security Income is SSI or Title 16. SSDI, as I said, requires a work history and enough quarters of coverage, the FICA deductions, to be considered insured. If you're not insured, you're not going to get the benefits. whereas SSI does not require a work history. And in fact, the program was originated in 1973, was promulgated by Congress back then because of a recognition that there weren't adequate or similar programs across the country for the elderly and the disabled. New York may have had a program, but Mississippi had no program, or another state had a program that was not helping support the disabled and elderly. And it was a different Congress than the Congress right now, and enacted the SSI program in 1973 to make sure there was similar benefits throughout the country for the elderly and the disabled. So it's not based on work. It's to cover those people who don't have a work history, maybe didn't work for a long time and their insured status expired, or who maybe never worked. I think there was a recognition at the time that it would help women who did not work outside the home, which was certainly more prevalent back in before the 70s. And so that was another basis for creating this SSI program. If you're on a SSDI or applying for it, other income you have other than earned income is not going to be counted, either in terms of your eligibility or in terms of the amount of benefits you may get. Your benefits are determined in the SSD program in an actuarialized way. The more you put in from the FICA payments, the higher your monthly benefit is going to be. People's benefits, individual benefits, differ from person to person based on work history. I think the current average is maybe $1,600, but that's not necessarily what you'll see your clients coming with. They may have work history that they were lower paid, and therefore their SSD, when it's calculated, will be lower. If they have earned income, it will affect their benefits. Obviously, it would also affect their ability to demonstrate that they can't work. But you will see that some people do work under an incentive earnings program or other ways where you're dealing with whether the earned income matters or not. But non-job related income won't be counted, and that would be interest from savings accounts, dividends from stock accounts, things such as that. For SSI, any income affects eligibility, number one, and then if it's low enough that you can get on SSI, it's going to affect your benefit amount. We do have a different DAP Basics session on SSI income eligibility, so you'll hear a little more about the complicated ins and outs of how income affects SSI. Same with resources. For SSD, there's no resource limitation. You can have $1 million in the bank. You can own property all over the world. You can still collect your Social Security disability. But for SSI, you really have to be very poor, both in terms of the amount of money you get each month and resources. You can't have liquid resources of more than $2,000 for an individual. There's a separate couples rate for SSI. There's very much this belief by Congress that two live more cheaply than one, so it's only $3,000 for a couple. So that would be savings accounts, any other kind of accounts like that could be considered available and liquid enough to be used for your support. There's a special burial account provision, $1,500, but there are lots of exemptions. And the one major exemption that people worry about the most is the home in which the claimant lives. That is considered exempt. Now, if it's a two-family home and they're getting rent from the upstairs, then it becomes a different question of both income and resources. But the home in which one lives is considered exempt. You can get SSI if you own a home. For the SSD program, there is a 5-month waiting period from the onset of disability. There is currently pending legislation to try to eliminate that waiting period, but it does still exist. So often you are not going to see that in practice because usually these cases take long enough as they go through the appeals process that 5 months from onset has long passed, but it will affect how much the retroactive payment is. retroactive payments are very much part of the calculation in these cases. As you see from the next point, retroactive benefits can be paid up to 12 months prior to the date of the application in an SSD claim. So that can be important. That can be a lot more money. Even if someone gets $1,000 a month, you could get a significant amount of money if you can get an extra year of back benefits and retroactive benefits. But your onset would have to be 12 months plus 5 months before, in order for you to get that full 12 months. So understanding that when you have an SSD claim with retroactive benefits can be complex. You're probably not going to learn all about it from this presentation right now, but you should know that it's an issue and something that you can look into more if and when it comes up. With SSI, there is no waiting period. On the other hand, you just get benefits from the month of application, not from any time before. But if you have a client who applied in 2021, May of 2021, the hearing where you win their claim is not until December 2022. If they had an onset date before the date of application, which would be typical, they'll get that full year and a half of retroactive benefits. With SSD, the benefits are paid for a month behind. In other words, your benefit that you get for May is not going to be paid until June, whereas SSI, your June benefit is for June. It pays forward. That doesn't come into your day-to-day practice much, but it's helpful to know from clients' questions. SSD entitles someone to Medicare coverage after 24 months. And that can be a very important part of people's claim, to be able to get that kind of health insurance, particularly for people who aren't poor enough to be eligible for Medicaid, 2 different healthcare programs. Medicare is usually thought of as a program for the elderly, but it also is available to people who have been on Social Security disability for 24 months. A premium is taken out of people's Social Security benefits for that. However, in most states, including New York, and in a majority of states, including New York, claimants are eligible for Medicaid, even if they're only getting $1 of SSI. Why would they only get $1 of SSI? Well, again, stay tuned for the session on SSI income. But they might receive some SSD each month, but it's low enough that they're still entitled to SSI. And in those cases, their Medicare premium will often be paid for by Medicaid. Things you'll learn when you start winning cases and deal with the post-entitlement issues. So where do you learn all these things and look up the questions that you have? Well, there's lots of different resources. This slide tells you where all of these laws and regulations come from. And we do have another session that is devoted to sources of law that will go over this in more detail. So suffice for now to know that it's a federal statute. The Congress creates these programs and legislates the details of the programs, and you see this, the 42 USC 401 for Title II and 1381 for SSI. It's administrative law. The statute is broad and gives authority to the Commissioner of Social Security to promulgate regulations through the administrative law regulatory process. Regulations will be proposed in the Federal Register and eventually promulgated in the Code of Federal Regulations. Part 404 for Title II, 416 for SSI. The disability components of those 2 sections are exactly the same. They differ in terms of the Title II insured status type of eligibility questions. For SSI, 416 has separate regulations on income, resources, etc. Case law is very important in this area of the law. Claims, it's a federal system. Claims get appealed to the United States District Courts and can be appealed again to courts of appeals or the Supreme Court. And so there's a lot of law that has interpreted the statute and the regulations. Social Security rulings are also relevant, SSRs, that Social Security publishes to give further detail to adjudicators about how it interprets the statute and regulations. And they can be quite helpful to advocates in some instances, sometimes used against your client, but often can be used in your favor in arguing cases. Social Security also publishes acquiescence rulings, and those are situations where Social Security is announcing that it will acquiesce in or agree with and abide by a ruling from a circuit court or the Supreme Court. What's very important in this practice is POMS, the Program Operation Manual System. Some of those are Social Security's internal rules. They aren't really regulations, but they really govern the day-to-day operations of Social Security adjudicators, particularly at the initial and reconsideration levels. And you'll hear about those terms in our DAP Basic presentation on the appeals process. But POMS governs procedural issues, but also much on income, resources, disability determinations, all included in the extensive POMS. HALEX, hearing appeals law, lex is the Latin for law, really governs more the operations of the Office of Hearings and the Appeals Council, a little bit more procedural than substantive. All of these are available at www.ssa.gov. It's a good website where you can find these program rules. And again, more details about that in our session on sources of law. So, overview of the two programs to get you started and begin to understand all these many terms and letters and alphabet soup that are flying about. So, thank you, and come back for more.